Third, State's Attorney's present, defendant and defense counsel are present. We have met informally with regard to some changes in the court's proposed charge. I've given you each a copy of the charge with those agreed upon changes. Are there any other requested additions or corrections or objections? I'll give you all both just a second to make sure. I just found something. On page 4 under parole, it has that example, which says if he's, and it's really just an example, but it says if he's sentenced to 4, then he has to do 2. It just is confusing because he can't be sentenced.
And I hate that, but it's actually part of the quotated language that the statute says shall be included.
It is, okay, I'll just leave.
I don't think we can
Yeah,
omit it.
okay.
Now, I guess we
It's
could
just
without
that,
objection, but
well, I don't think, I mean, it's not saying he's going to get that, it's just explaining to them how to do math. So, okay, never mind then. All right, so anything else with regard to the charge, Mr. Smith?
no, Judge.
Mr. Vasquez?
Judge, is there, well, never mind, just found it. Sorry.
You're good. It's all good then?
Can I have one more minute here?
Yes, sir. On page 3,
Yeah, page 3.
where it says the state has accused the defendant of having been convicted of a felony twice before, should I say of a felony at least once before or something like that?
I would take the twice out. I would say of at least.
What do you think it should say?
Here's the defendant of having been convicted of.
At least once before. That's the language that we keep using, is at least once before,
Right.
right?
Yeah, a felony. I just wait that sounds. I mean, of having been previously convicted of a felony, of at least one felony. Does that sound all right? It's not what we've been saying, though.
No.
Just for consistency, I guess.
I mean, it's that they both mean the same thing. I'm gonna use the at least just because we keep you, so it reads, the way I have it, the state has accused the defendant of having been convicted of a felony at least once before. That's what it says everywhere else.
Can you lose the at least, Your Honor?
But we've been putting at least everywhere else because it only requires one. And so I think that keeps it consistent with the other ones. Unless y'all both agree to take that out, but I think we've,
Just keeps it consistent all the way through the charge if you do it that way.
okay. All right, so there's that. What else?
I'm sure we'll see one about 3/4.
As soon as I'm reading it, I know. So I need to print page 3. Stapler, taker, I need to get one of these for my drawer here. Here should be page 3. Okay, with that modification now, are there any requested additions, corrections, or objections?
Not from the statement.
Nothing to finish, Your Honor.
All right. Anything else before we bring the jury in then?
Not from the statement.
Mr. Vasquez, anything else?
No, Your Honor.
All right, you can bring the jury in. Good morning. Let the record reflect that the jury is seated, state's attorneys present, defendant and defense counsel are present. And so let's get caught up on where we are from yesterday. The jury reached a verdict of guilty in cause number 23 DCCR 0329. At this time, I accept your verdict, find you, Mr. Westbrook's, guilty of the offense of murder. Mr. Smith, you may read the remainder of the indictment. Mr. Westbrooks, if you'll please rise.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted of the felony of burglary of a habitation, second degree, on April 9th, 2012, in cause number 10-08944 in the Criminal District Court of Jefferson County, Texas.
And Mr. Westbrooks, is that true or not true?
True.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery, second degree, and on April 29, 2013, in cause number 12-14152 in the Criminal District Court of Jefferson County, Texas.
And is that prior conviction true or not true?
True.
All right, thank you, sir. You can have a seat. All right, Mr. Smith, do you wish to make an opening statement?
Just briefly, Judge.
Go ahead.
Ladies and gentlemen, I want to thank you again for your time, for your verdict. I'm sure it was a proper verdict under the law and the facts and the evidence that was given to you in this case. We talked about the separate stages in a criminal trial when we were in Rhode Island. And I told you in the first phase, it's not the time for sympathy, emotion, or compassion. It is simply to determine if the facts amount to a crime. If so, then guilty. If not, then not guilty. Guilt is over. Now we're into the punishment phase. This is where you as jurors help me help all prosecutors out, because this is the benchmark part. This is the part where we know what a jury says should happen to a person with this kind of criminal history, commits this kind of crime in our community, what should happen. So that becomes the job now. And for that, you can take in the totality of the circumstances. You can take in sympathy, emotion, or lack thereof, good things that he's done, bad things that he's done, all of that, that big picture. And he can be punished based on all of that, not just on that short window of his conduct at that time. Okay? So I just want to let you know that, and thank you again for your verdict. We're going to give you some more evidence, and then we'll get you back to deliberating on the punishment in this case. Thank you.
Thank you, Mr. Smith. Mr. Vasquez, do you wish to make an opening statement?
Very briefly, Your Honor. Would you want Mr. Smith and
Thank you for your service. Respect your verdict, and be back to talk to you again during closing argument.
All right, thank you, Mr. Vasquez. Mr. Smith, you may call your first witness.
We call Troy Robinson.
Good morning, sir.
Morning.
Do you swear affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can have a seat. You may proceed.
Good morning. Would you state your name and spell it for the court, please?
Troy, Troy, Robinson.
And what is your occupation?
I'm an investigator for the Jefferson County District Attorney's Office.
How long have you been so employed?
A little bit over 7 years with the District Attorney.
Are you a certified peace officer in the state of Texas?
Yes, I am. I hold a master's certification.
And what are your duties as an investigator for the district attorney's office?
So our duties are to assist the attorneys in preparation for trial, look over some of the case files, obtain statements, evidence, locate witnesses, serve subpoenas, testify in court, and particularly for my case, I do some fingerprint comparison work.
Okay. And prior to being at the district attorney's office, where were you employed?
I was at Port Arthur PD for 20 years. I retired from there and then moved over to here at the DA's office.
So are you a fingerprint expert?
Yes, I have been certified as one in this court.
What training and background do you have that qualifies you as an expert in the area of fingerprint identification?
So in 2018, October 2018, I attended a 40-hour core course at Texas Forensic Associates. It's a fingerprint comparison school. Once you complete the course, obtain your certification, you maintain some regular training, and basically we'll call it like testifying in court is part of that. And I've testified in the 252nd District Court on many occasions.
That was going to be my next question. Have you testified before as an expert in district courts here in Jefferson County?
Yes, I have.
Many occasions?
Yes, I have.
What is a fingerprint?
So a fingerprint is a friction on your fingertips or your thumb. You have friction ridges. On the friction ridges are basically oils that your body produces. When you touch something, it's possible to leave a fingerprint, which is considered a latent print. Now, latent print is invisible to the eye, so you can't really see it. So what you have to do is use like chemicals, powders, things of that nature to bring the print visible, so you can like obtain it from whatever surface or object it may be on.
Have you ever found two people to have the same fingerprints?
No, your fingerprint is a biologically unique to you yourself.
Have you ever heard of anybody having two different people having the same fingerprint?
No, I have not.
What is an inked print?
So an ink print is exactly what it states. We basically take a pad, it has some ink on it. When you touch your fingertip to it and you put it on a piece of paper or any other substance, it's going to leave a visual marking of the fingerprint from the ink itself.
Approach that.
Yes, sir.
Show has been marked as State's Exhibit number 22. I'll ask if you recognize that.
Yes, I do.
What is that?
So this is a fingerprint card that I took yesterday from Mr. Paul Westbrook Jr.
So you took and inked his fingerprint, or his fingers, and then put them on that card, put the prints on that card?
That is correct. I actually had to take 3 fingerprints. We mostly in court use the thumb, the right thumb, the left thumb. I had to take the right thumb twice. The first one was kind of light and I didn't really like it. So I took 2 of the right thumb and 1 of the left thumb. And that's on it State's Exhibit 22.
Okay. Now at this time, we'd offer State's Exhibit 22 into evidence.
No objection to 22, Your Honor. I was actually present when Ms. Robinson did his work.
Thank you, Mr. Vasquez. 22 is admitted.
I guess, so you made that yesterday. Do you see in the courtroom today the person whose inked fingerprints appear on that card that's been marked State's Exhibit number 22?
Yes, sir, I do.
Would you point him out to the jury, please?
The gentleman sitting over next to Mr. Vasquez.
Gonna let the record reflect he's identified the defendant in this case.
The record will so reflect.
Now, let me show you what's been marked as State's Exhibit number 33. Can you identify that?
Yes, sir, I can.
What is it?
So this is a judgment in the state of Texas versus Paul Edward Westbrooks, AKA Paul Edward Westbrooks Jr., under the case number of 10-08944 in the Criminal District Court of Jefferson County, Texas.
Does it contain a set of fingerprints made by the defendant that was sent to the penitentiary as reflected in that certified copy?
Yes, in the certified copy, there is a right thumbprint from the comparison of the judgment in the fingerprint card. It is Paul Edward Westbrooks, AKA Paul Edward Westbrooks Jr., which was a judgment of guilt for burglary of a habitation. Date of the judgment entered was 4/9/12. The offense date was 6/28. Sorry, 1/29/2010. And he received 5 years in TDCJ.
Have you compared the inked fingerprints on State's Exhibit number 22 with the inked fingerprints in State's Exhibit number 33?
Yes, the fingerprint on State's Exhibit 22 and 33 are exact.
Okay, so your opinion is that the fingerprints were made by the same individual?
They are.
Do you have those, when you do a comparison, do you often compare it, but do you have it verified by other fingerprint experts?
Sometimes we do, sometimes we don't. It depends on our manpower. Currently, we're a little short on manpower, so for this one here, this was completely done on my own.
Okay. Was this a difficult comparison?
No, it was not.
Show you what's being marked State's. Well, actually, Judge, at this time we'd offer State's Exhibit number 33 into evidence.
Your Honor, Mr. Westbrook is admitted to this prior earlier. We have no objection.
State's 33 is admitted.
We'll show you what's been marked State's Exhibit 34. Ask if you recognize that.
Yes, I do.
What is it?
This is a judgment of the state of Texas versus Paul Edward Westbrooks Jr., AKA Paul Westbrooks Jr., AKA Paul Edward Westbrooks Jr., case number 12-14152 in the Criminal District Court of Jefferson County, Texas.
And does it contain a set of fingerprints made by Mr. Westbrooks, who was sent to the penitentiary as reflected in that certified copy?
Yes, it does.
Have you compared the inked fingerprints on State's 22 with the inked print in State's Exhibit 34?
Yes, I have.
And do you have an opinion as to whether the fingerprints were made by the same individual?
They are.
What was the sentence received in that?
So on this judgment, the defendant was convicted of robbery. The date of the offense was 11/21/2011. The date the judgment was entered was 4/29/2013. It was a second-degree felony, and he received a term of 12 years in institutional division. It doesn't list it as TDCJ. Oh, yes, it does. Down on punishment, place, and confinement. Sorry.
Okay. So he received 12 years in that case.
That's correct.
We show it's been marked, or actually, at this time we'd offer State's Exhibit 34 into evidence. Certified copy of the public record.
Mr. Westbrooks has pleaded through to this one as well, Your Honor. We have no objection.
States 34 is admitted.
We show what's been marked State's Exhibit 35. Do you recognize that?
Yes, sir, I do.
And what is it?
This is a judgment of the state of Texas versus Paul Westbrooks Jr., AKA Paul Edward Westbrooks Jr., case number 12-13415 in the Criminal District Court of Jefferson County, Texas.
And does it contain a set of fingerprints made by Mr. Westbrooks, who was sent to the penitentiary for?
It contains a thumbprint, yes.
Have you compared the inked fingerprint on State's Exhibit 22 with the inked fingerprint in State's Exhibit number 35?
Yes, I have.
And do you have an opinion as to whether or not those fingerprints are made by the same person?
They are.
And what was that conviction for?
So this conviction is a state jail felony of evading arrest, detention with previous convictions. The offense date was 1/23/2012. Date of judgment 4/9/2012. And he received a 2-year sentence to run concurrently with another case in the Jefferson County, out of Jefferson County, Texas.
This time we'd offer State's Exhibit 35 into evidence.
No objection to State's 35, Your Honor.
It's admitted.
And you look at marked State's Exhibit 36. Do you recognize that?
I do.
And what is it?
It's a judgment, the state of Texas versus Paul Edward Westbrook Jr., AKA Paul Westbrook Jr., case number 12-13598 in the Criminal District Court of Jefferson County, Texas.
Does it contain a set of fingerprints made by Mr. Westbrooks, who was sent to the penitentiary for that offense?
Yes, it does.
And have you compared the inked fingerprints in State's Exhibit 22 with the inked fingerprint in State's Exhibit 36?
Yes, I have.
And do you have an opinion as to whether or not those fingerprints were made by the same individual?
They are.
And what was the sentence received in that case?
So this is evading arrest, detention with previous conviction. Date of offense 1/24/2012. Date of judgment entered 4/9/2012. And this was confinement in state jail for a term of 2 years to run concurrently with other cases.
This time we'd offer State's Exhibit 36 into evidence.
No objection to State's 36, Your Honor.
States 36 is admitted.
Permission to publish this to the jury.
Yes, sir.
Vice witness.
Thank you, Mr. Smith. Mr. Vasquez, any questions?
No questions for this witness, Your Honor.
Any objection to Investigator Robinson being excused?
No, Your Honor.
Okay.
Thank you, sir. You may call your next witness. At this time, you have heard all the evidence, obviously in the guilt-innocence phase and the additional evidence in the punishment phase of the trial. The next part is just like the previously. I have the court's charge. It is ready. I'm going to read the charge to you. Then you will hear closing argument by counsel, and the case will be given to you for deliberation. Clause number 23, DCCR 0329, jury instructions. Members of the jury, You have found the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., guilty of the offense of murder. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only
This is the point where the punishment phase becomes especially significant. The court has explained that if the prior felony conviction is proved true, the punishment range starts at 15 years and can reach 99 years or life. The prosecution has also presented fingerprint evidence connecting Westbrooks to multiple prior judgments, including burglary and robbery convictions. Now, the state is emphasizing something much bigger than a single previous offense. The prosecutor tells the jury this is Westbrooks' fifth felony conviction. That history is being presented as part of the broader picture the jury may consider when deciding punishment. But the jury still has a responsibility to make its own decision based on the evidence admitted in court. So, with a range stretching from 15 years all the way to 99 years or life, what punishment would you consider appropriate after hearing this history? The jury now has a difficult task of deciding where within that enormous range this case belongs.
Evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide the punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added, and the result is divided by 12. To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the vote, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. And 5. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. You have found the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., guilty of murder. The state has accused the defendant of having been convicted of a felony at least once before. The defendant has pleaded that this accusation is true. The range of punishment depends on whether you find the defendant has one prior felony conviction or no prior felony convictions. Any prior conviction must have been any prior conviction must have been final prior to the commission of the offense for which you have found the defendant guilty. Relevant statutes. Punishment if accusation of at least one felony conviction proved true. If the state proves that the defendant has at least one prior felony conviction, this offense is punishable by 1. Any term of imprisonment for no less than 15 years and no more than 99 years or for life, or 2. Any term of imprisonment for no less than 15 years and no more than 99 years or for life, and a fine of no more than $10,000. Relevant statutes. Punishment if neither accusation proved true. If the state does not prove either of its prior conviction accusations, this offense is punishable by 1. Any term of imprisonment for no less than 5 years and no more than 99 years or for life, or 2. Any term of imprisonment for no less than 5 years and no more than 99 years or for life, and a fine of no more than $10,000. Other relevant statutes. Burglary of a habitation and robbery are both felony offenses. Burden of proof. The state must prove beyond a reasonable doubt the prior conviction's accusation. Parole. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, he must serve at least 2 years before he's eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Application of law to facts. You must determine whether the state has proved, beyond a reasonable doubt, its accusation of one prior felony conviction or no prior felony convictions. The elements of these accusations are that 1. The defendant was convicted on April 9, 2012, in cause number 10-08944 in the District Court of Jefferson County, Texas, for burglary of a habitation, a felony, and it was final before the commission of the offense for which the defendant was convicted in this trial. 2. The defendant was convicted on April 29, 2013, in cause number 12-14152 in the District Court of Jefferson County, Texas, for robbery, a felony, and it was final before the commission of the offense for which the defendant was convicted in this trial. If you all agree the state has proved beyond a reasonable doubt either elements 1 or 2 listed above, you must find the accusation of prior felony conviction true and complete the verdict form below titled Verdict, Accusation of 1 Prior Conviction True. If you all agree the state has failed to prove beyond a reasonable doubt any accusations of prior convictions, you must find the accusations not true and complete the verdict form below titled Verdict, Accusation of Prior Convictions Not True. And then that has my signature. And then you have 2 separate forms. You'll just select one of the forms and fill it out accordingly to with your verdict. The first is verdict, accusation of 1 prior conviction true. We, the jury, having found the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., guilty of the offense of murder, find at least 1 prior conviction has been proved true. We assess the defendant's punishment at, and then there's 4 options. You would select 1 if this is your form. Imprisonment in the Texas Department of Criminal Justice for a term of blank, 15 to 99 years and no fine. Imprisonment in the Texas Department of Criminal Justice for a term of blank, 15 to 99 years and a fine of blank, $10,000 or less. Imprisonment in the Texas Department of Criminal Justice for life and no fine. And then the last option is imprisonment in the Texas Department of Criminal Justice for life and a fine of blank, $10,000 or less. And that's got the line for the signature and the printed name of the foreperson. And then the second verdict form, verdict, accusation of 1 prior conviction not true. We, the jury, having found the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., guilty of the offense of murder, find that no accusation of prior convictions has been proved true. We assess the defendant's punishment at, and then 4 options. You would select 1 if this is your form. First, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years and no fine. The second, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 and a fine of blank, $10,000 or less. The third is imprisonment in the Texas Department of Criminal Justice for life and no fine. And then finally, imprisonment in the Texas Department of Criminal Justice for life and a fine of blank, $10,000 or less. Again, that has the spot for the signature line and the printed name. And again, you just select 1 of those forms. Mr. Smith, the state has the right to open and close. Closing argument?
State will waive initial part of closing argument and reserve we'll waive opening and reserve close.
Gotcha. Thank you, Mr. Smith. Mr. Vasquez, you may proceed.
Thank you, Judge. Mr. Smith, Ms. Molfino, Mr. Westbrook. I watched y'all looking at those prior judgments during, while the judge is reading the jury trial. Jesus, it's like I were memorizing. It's like just pass them on, read them, pass them on. Mr. Westbrook is admitted to his prior history. I don't have a clue what to say or what to talk to you about. I've been here all week. And I get stumped periodically during the week, but this is when you really just don't know what to say. Do not hold it against Mr. Westbrook for not testifying during this phase, or either phase. It's my advice for him not to testify. Not public speaking, it's not for everyone, it's not everyone can be on the debate team, it's hard to speak. You 12 are the ones that are going to met out Mr. Westbrook. a very violent world. Most of us don't have the contact that kind of, so it doesn't do so. I know he has to be held accountable for what he found guilty of. I just hope you balance it with some mercy. I anticipate Mr. Smith's gonna stand up and ask you to punish Mr. Westbrook with many, many years. He's a young man. I just hope you give him a chance to get out for the second part of his life and have a life.
Thank you, Mr. Vasquez. Mr. Smith?
Judge, please, court, counsel. There are a couple of things for you. Based on feedback, I could do this for going on 3 decades now. The fine. You can assess a fine if you so choose. That's what the statute reads. To answer any possible questions, the fine does not go to the victims. The fine does not go to anybody. And if he goes to prison, which he will in this case, there's no mechanism to make him pay that fine. So don't get mad at each other because somebody says you want to do a fine. I've had juries that do a fine knowing that will still do it to make an exclamation point. But even when he gets out on parole, there's really no mechanism. He'll be ordered to pay it, but if he doesn't, nothing is going to happen to him. He doesn't go back and don't pay the fine. So don't concern yourself overly with the fine. Second thing is, in this particular case, the way things are, we have to prove the prior beyond a reasonable doubt. So that's why we give you fingerprint experts to show that this is the same person that was this, even though the name's the same, all that's the same. So I submit to you that the only one you need to worry about is the verdict page. Accusation of one prior conviction is true. That there's more than sufficient evidence to find that that is true. The second thing, and even though the statutory language about that has to be part of the charge so that you understand that whatever he gets from you, he will have to serve half of it. And that, even though you can't give a 4-year sentence, that's part of the language. So that's why you were given it. It just shows the math. Anything you give half of that is what he will have to do before he's eligible for parole. And you can consider that there is parole. You just can't consider how it will be applied to him because we don't know. You don't make that decision. I don't make that decision. The judge does it. It's up to the bargaining parole, which whenever that happens, so the question becomes, if that's true, if the prior is true, then his range is no less than 15 years or more than 99 years or life. And the other part of that statutory language tells you half of whatever you give him or 30 years, whichever is less. So if you're not good at math, that means anything from 60 to 99 years or life, the parole eligibility remains the same. So there's no use to do that over something like that. So then that really becomes your question is what do we do with somebody like this? And what you do here today will tell me what I need to do the next time one of these rolls up on my desk and I have to make an offer. We talked about that. Most of these cases work out before they ever get this far along in the process. So there is a full range. Just like in every crime in the state, there is a range of punishment. This just happens to be a very wide range. There's a huge difference between 15 years and 99 years. And I told you, you can take anything into consideration. Any evidence that you have that he's done good for the community. Anything that you have that he's done good for his family or his friends or anything. You can take all that into consideration. Anything that he's done bad, you can take that into consideration. You can take into consideration the fact that this isn't his first felony conviction. This isn't his second felony conviction, or third or fourth felony conviction. This is his fifth felony conviction. Once can be a mistake. Twice can be hanging around the wrong people. 3 times can be not proper decision making. But what is 5 times convictions? I submit to you, I'm not going to tell you, I'm not going to give you a number. I'm going to leave that up to you. Whatever you come up with, I can live with, the judge can live with, and Mr. Westbrook can live with. Because we all should be accountable for what we do. There are consequences that go with the choices that we make. It's just like if you take a stone and you throw it into the middle of a perfectly clear, calm pond. There's going to be ripples that go out all the way to the edge. It can affect people for generations. So, I submit to you, you do what you think is proper under these circumstances. We know that there wasn't just one victim. 2 people lost their lives. They got the death penalty for what happened that night. We have multiple victims that survived it, that are still traumatized by it. We have things that I look at when I'm deciding what to offer, especially when you have a big range like this, is what did they do afterwards? What did they do after they committed the crime, when they had time to cool down and to think? Did they come forward? Did they confess? Did they repent? Or did they lie, hide the evidence? Did they get other people to help them commit that crime? Did they help? What did they do? What has he done that would warrant mercy? Mr. Vasquez asks for mercy. Defendants always ask for mercy. The way I look at it, justice is when we get what we deserve. Mercy is when we don't. We've come a long way. I hate to have had to bring you down that road. I see it all the time, unfortunately. A lot of good folks who come out of our community have no idea what happens at these houses in the middle of the night. But you know what happened that night. You know the consequences of what happened that night. You know what accountability is. And after you come back with a verdict, then and only then will Mr. Westbrook's know what accountability is. But you're telling me that, and there's reasons for punishment. Why do we do this? One is general deterrence. Knowing that there is a punishment up to the rest of your life could be spent in prison for committing crimes will keep a lot of people from committing that kind of crime. Some people, that doesn't seem to affect at all. So you have specific deterrence. Well, it may not keep other people from doing it, but it's certainly going to keep you from doing it. It's going to keep our community safe from you. There's so many reasons for punishment. what you're doing today will tell me what to do next time it gets on my desk. But it's also be just like if you put it on a billboard. Interstate 10 runs right through this county. And it's gonna say, hey, you go into somebody's house with guns and violence and threats, into someone's home where they have a right to feel safe, no matter what kind of person they are, no matter what kind of things they do. They have a right to feel safe and secure and peaceful in their own home. When you go in and destroy that and kill them, what happens to you in Beaumont, Texas, in Jefferson County, Texas? Because the word's gonna get out. It's gonna be on the news. It's gonna be everywhere. And everybody else that's got a gun that they stole from somebody's truck and an idea of where they can go make an easy lick, they'll have at least warning about what happens if they choose to do that in our community. I'm not telling you what to do. I'm just telling you to let the punishment fit the crime. Let there be justice in this case. Justice is what he deserves. That's what we deserve. Thank you for your time.
Thank you, Mr. Smith. So, ladies and gentlemen, you've heard all the evidence, the court's charge, and closing argument by counsel. I am giving the charge to the bailiff. She'll get you into the jury room with that charge. All right, we're back on the record. State's attorney's present, defendant and defense counsel are present. I've received a message that the jury has reached a verdict. If you'll please bring the jury in. And let the record reflect the jury seated, state's attorney's present, defendant and defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict on punishment?
We have,
And is it the unanimous decision of all the members of the jury?
it is.
Thank you, sir. You can hand it to the bailiff. Okay. Mr. Westbrooks? We, the jury, having found the defendant, Paul Edward Westbrooks Jr., a.k.a. Paul Edward Westbrooks and Paul Westbrooks Jr., guilty of the offense of murder, find at least one prior conviction has been proved true. We assess the defendant's punishment at imprisonment in the Texas Department of Criminal Justice for a term of 55 years and no fine. You can have a seat. Does either party wish to have the jury polled?
Yes, no, yes.
No, Your Honor, this is unanimous.
Thank you, Mr. Vasquez. All right, Mr. Westbrooks, at this time, in conformity with the jury's verdict, I sentence you to a term of 55 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you, you have on your table the trial
The
court
punishment
certification.
phase has now reached its final result. Paul Edward Westbrooks Jr. was already found guilty of murder, and the jury unanimously determined that at least one prior felony conviction had been proved true. That finding placed the applicable punishment range at 15 years to 99 years or life, giving the jury an extremely wide range of possible sentences. After hearing the evidence about Westbrook's criminal history, including prior burglary, robbery, and other felony convictions, the jury ultimately assessed his punishment at 55 years in the Texas Department of Criminal Justice, with no fine. The judge then formally sentenced him in conformity with that unanimous jury verdict. The court also explained that Westbrooks would receive whatever custody credit the law provides, and that he would be remanded for transportation to the Texas Department of Criminal Justice. The case therefore ends with a 55-year prison sentence after the jury weighed the murder conviction and the proven prior felony history.